So, mediation is a process where you sit down and try to resolve your differences without going to court. Typically, you're going to be in one room with your attorney, and your spouse is going to be in another room with their attorney. Sometimes people do it by Zoom, so they're in different Zoom rooms. But you don't sit together in the same room trying to hash things out. You negotiate by having a mediator who's a third party, a neutral person, and they go back and forth in between the rooms and they try to broker a deal essentially. Now, that mediator is someone without power. They are not a judge. They can't tell you what to do. They can't tell your spouse what to do. They also can't give you legal advice. That's what your lawyer is for. But they can help try to break the logjam and help you guys come to a resolution that's workable for both of you. If you go to mediation and you come to an agreement with your spouse on all of the issues in your divorce, whether that's financial issues or kid issues, if you come to an agreement on all of that, that is documented in a mediated settlement agreement. That mediated settlement agreement is a binding agreement. There are no takebacks. So when you sign off on that mediated settlement agreement, be very certain that is what you want to happen in your divorce. Once that mediated settlement agreement is signed, then the attorneys will turn that into a final decree of divorce that the judge will sign off on. Your mediated settlement agreement may be a few pages long, but your divorce decree will be a long document, anywhere from 30 to 50 pages, depending on whether there are kid issues involved. And that long document will be the exact terms of your divorce based on what you agreed to in mediation. If you aren't able to settle your case in mediation, you will have a trial in front of a judge. Your spouse will present their side and ask for what they want out of the divorce, and then you and your attorney will present your side and ask for what you want out of the divorce. That trial can last anywhere from a few hours to a few days. Usually it's in front of a judge, but sometimes there might be a jury, a number of people who would decide your case and tell you what's going to happen. The best thing about mediation is that you have control over the outcome. You have control over what you agree to or don't agree to. In a trial, someone else is making decisions for you, whether it's the judge or whether it's a jury. Someone else is making decisions for you and your family, and you don't have control anymore. When you go to mediation, the goal is to come to a resolution at the end of the mediation. So if you're going in for a half a day mediation, you have 4 hours to hopefully come to a settlement. If it's a full day, you may have 8 hours. Now, the mediation can continue beyond that. A lot of times, if the mediator thinks that you're making progress, maybe it's slow progress, but progress is being made, they'll keep going. I've been in 14-hour mediations in order to get a deal done. Sometimes, if you're making progress, maybe you stop for the day and come back on another day to finish. So the mediation can last as long as people feel that it's being useful and productive. But if one party believes that this is all I'm going to do and I'm not going to negotiate it any further, then usually the mediation is going to stop and you're going to end up in court. Sometimes you're sitting in mediation and you know you have to deal with all of the issues in your divorce, and that can be a lot. It can be a lot to handle at one time. Often you may be able to handle just one portion of your divorce. Maybe you just address the kid issues in one mediation, come to a partial agreement, and then come back on another day and handle all the financial decisions. It's really a decision for you and your lawyers how best to manage that and the amount of time that you have. Sometimes the mediator needs to run and go to another case, or the lawyers have competing schedules. And so it's not always possible to get it all done in one session or one day. But if the parties are making progress, that can be continued into another day. One of the best things that you can do in preparing for your mediation is to make sure that you are physically ready for that. Make sure that you've got a good night's sleep ahead of time and that you've had a good meal and that you have been drinking water. It can be a long and strenuous process, and you're going to be making a lot of important decisions. So you want to make sure that you're in the best physical health that you can be in order to make the best decisions for you and your family. Other ways that you can prepare for mediation is to have a pre-mediation meeting with your attorney so that you know what to expect. You have talked about what your goals are, with the understanding that sometimes those goals pivot in mediation depending on the other side, and sometimes you learn things that change your goals. Having at least a pre-mediation meeting with your attorney can help you identify the key things that you want to get out of your mediation and make sure that everyone is on the same page. If you have more questions about the mediation process, give us a call at DeFord Law Firm.